European states have basically been cooperating in these areas for 30, 40 years. We can go back to the Council of Europe conventions on mutual legal assistance and extradition of the late 60s. But what's been happening in the last decade or so is that this system of kind of cooperation is being replaced by a sort of federal EU criminal code. Now, again, about a decade ago, there was serious debate about whether we should have what they called an EU corpus juris, which would be a whole new legal system that would just establish a whole new set of rules that would apply across the EU. Now, because of the wide and varied legal traditions and systems in the member states, this was rightly rejected out of hand. But what we seem to have in its place is a kind of almost botched federal criminal code that's kind of being slowly pieced together, and this is really based on two processes. The first is the harmonisation of offences and the introduction of EU-wide criminal laws, and here we've seen a number of specific problems. First, this isn't just being limited to serious offences that everyone could recognise, require cooperation. We now have what is effectively an EU schedule of 32 criminal offences that we see now that most of the EU criminal law applies to. And this includes, some minor offences and some offences that some states have criminalised severely, and other states have chosen either not to punish or not to punish so severely. And the main problem we have is that we get these overbroad definitions. So certainly it's been the case with terrorism, the facilitation of illegal entry and residence, drug trafficking, cybercrime. There was another attempt to bring in a directive on the infringement of intellectual property law, and all of these, they're coming up with extremely broad, not quite catch-all definitions, but laws that have the effect of criminalising more and more conduct, including conduct that traditionally has not been seen in such severe terms. So we're basically talking about a broadening of the criminal law through the adoption of EU measures. The second aspect of this, of what's happening in the area of EU criminal code, is what's called the mutual recognition programme, and as I mentioned before, a system of kind of warrants that replace the principle of cooperation. So where once states enjoyed some discretion over whether to execute a request for legal assistance or police assistance, and they would apply tests such as dual criminality. Is this an offence that we recognise here in our own country? Should we be going after these people, if you like? Is this an offence of a political nature? Are there human rights concerns? What we're seeing as the EU criminal code is developing is that this discretion and these tests are being given less and less regard, or being undermined altogether. So now EU states can or soon will be able to issue warrants that must be enforced across the EU for arrest. We have the European arrest warrant. For expulsion orders, we have the mutual recognition of expulsion orders. So expulsion order for one member state must now be enforced throughout the 27. We have a European evidence warrant, which hasn't yet formally been agreed, but it's the negotiations at a very late stage. This will effectively provide for cross-border search and seizure. We have more warrants for the freezing of assets and evidence, and we have warrants for confiscation orders for the proceeds of crime. Now, like I said, it's all fairly complex stuff, but it causes a number of potential problems for suspects and defendants. As I said before, the overbroad definitions of offences mean that these can apply to more and more minor conduct. Now, we're aware of examples of European arrest warrants being issued in the case of possession of 2 grams of cannabis, theft of goats, You know, this is, we've seen it in the EU Council documents. You know, so these were measures that we were told to brought in to combat serious organised crime, and we find them being used for very low-level policing. Again, as I said before, these are coercive powers that are effectively being harmonised at a very high level, but questions relating to the rights of suspects and defendants are being ignored. So when the European arrest warrant was introduced, you had criminal defence lawyers saying, fine, well, let's have a system of Euro bail, or let's have some kind of standard that's going to bring an equal playing field to make sure the suspects and defendants' rights are looked after as well. I think I'm right in saying we've had somewhere in the region of 30 framework decisions or draft framework decisions. These are the measures that the EU uses to harmonise this area, all of which are geared towards the furthering of investigations and prosecutions. We haven't had a single measure on the rights of suspects and defendants, despite the fact that when the EU embarked on this programme, it said, look, we will have a twin-track approach here.